my name's Tom, and in today's Speaking Your Language video, I'll be talking about a case I find really valuable. It's called Regarding Visa Cancellation Applicant and Minister for Immigration and Citizenship. For convenience sake, I'm going to call it the Visa Cancellation case. First, I'm going to take you briefly through the facts of the case and what the tribunal ordered, before delving a bit deeper into how the tribunal came to its decision and why this is important. By the end of the video, I'm sure you'll see how this case helps us to begin to understand tribunal decisions better. Now, the facts here are pretty straightforward. While the judgment considers some other factors, the crux of the case is that the applicant was convicted for serious violent criminal offences in New Zealand, emigrated to Australia and lied about the convictions, he got called out, and subsequently he had his visa cancelled by the immigration minister. He asked the Administrative Appeals Tribunal to reconsider the decision, but he got the same answer. No, we don't want you here, back to New Zealand you go. All in all, the decision is quite short and quite simple. In my mind, the applicant's conduct made the tribunal's decision almost inevitable. What makes this case important is how the judges came to their decision. Before moving on, a bit of background info is needed here. In 1979, the Drake case decided that the AAT's job was to look at a government decision and decide whether it was the correct or preferable one, based on the material the tribunal had before it. Over the next 25 years, this phrase was quoted by courts dozens of times, including by the High Court of Australia. Then, in 2006, the High Court further explained this statement, telling us that tribunals are to make the most preferable decision, rather than the correct one, in discretionary cases. That is, in cases where there's no clear right or wrong, black and white answer, the tribunal has to weigh up several shades of grey alternatives, choosing the most preferable. The only problem was, no one had really said how to decide what was most preferable, until the visa cancellation case. Here, Justice Downes spelled it all out for us. First, he laid out the key interests tribunals take into account when they weigh up what the most preferable result is. He reminded us that a tribunal is not a court. While they might run similarly, a tribunal essentially acts as an extension of a government department. As such, it needs to keep in mind government policy and the needs of good administration when making its decision. Simultaneously, tribunals need to keep in mind the importance of achieving individual justice. In some cases, it might be preferable to achieve individual justice even when it goes against government policy. In others, it may not. This is the balancing act that tribunals need to engage in to find the most preferable outcome. When tribunals perform this balancing act, however, their personal feelings and prejudices don't come into the decision. Instead, Justice Downes tells us, the tribunal has to make the decision based on what the community at large would choose as the most preferable outcome. Now, this is a sticky subject itself, and there are volumes of discussion on the topic in legal articles and cases. We won't go too far into it, but it's important to think about community standards as a general public sentiment that's enduring. So we're not looking at what vocal minorities think or what the flavour of the month is, but values that are present, broadly accepted, and here to stay. And one last thing. Most of the time, tribunals won't accept evidence as to community standards, so it's important to keep that in mind. And that pretty much sums up the visa cancellation case. As you can see, it's an important case as it begins to fill a gap in the law, helping us to understand how tribunals decide what's preferable. While the decision doesn't give us a comprehensive statement of the test, it's certainly a good first step in showing us the way forward, giving future applicants like yourselves the tools you need to really target your arguments and help you get the most out of your appeal. I hope I have been able to help you in understanding this case. Administrative law can be a scary place. If you have any further questions, please don't hesitate to contact myself or one of my colleagues at the firm. Thank you.